Hello, students. Welcome to our asynchronous class on charging instruments, venue, and jurisdiction. I'm going to share my screen so you can see the PowerPoint. The PowerPoint is available on Lexis Classroom. So you should be able to see my screen now. I wonder if I should stop the video so out of my thumbnail's probably up there, but I don't think it's going to block anything. So let's get started. Okay, so let's first start talking about jurisdiction. I know there are lots of definitions of jurisdiction that you learn from civil procedure. For our purposes, it just refers to the court's authority to hear a case, not geography. And that refers to the different levels of court. Now, you already have a chart in your book, but let me just go over it very quickly. Class C misdemeanors, which are fine only offenses, traffic tickets, um, real petty shoplifting charges, or assaulting someone by offensive contact, like spitting on someone. Those are held in the JP, Justice of the Peace Courts, or municipal courts. Um, JP courts have the same jurisdiction over Class C misdemeanors and traffic, but they also do the small claims cases. Municipal courts will also do things like dangerous dogs, hoarding cases. What you really need to know for most of your exam purposes is going to be the upper level courts. So the upper levels would be the county criminal court at law. You know, of course, there's civil courts. So we're going to focus on criminal. That deals with Class A and B misdemeanors. A Class A misdemeanor is anything punishable by up to a year in the county jail. Think of unlawful possession of a weapon like a knife. Think of DWI, driving while intoxicated. Unless they've been charged like 3-4 times about with DWI, it's going to be a misdemeanor. Assault that causes bodily injury. Bodily injury is defined under the penal code as pain. That's also a Class A misdemeanor. All that will be heard in county criminal court. And if you're in Houston, Harris County, you know about the county criminal courts at law, number, what have you. Then you have your district courts. This is where your felonies are held. Think about your state jail felonies, which would be most of your drug cases. So not a little bit of marijuana, which would be in county court, but a lot of marijuana, cocaine, oxy, um, meth. You know, whether it's crack or powder cocaine. Most of those drug cases are going to be considered state jail felonies if it's a small amount. Larger amounts go up the chart to third degree, second degree, first degree felonies. Regardless if it's a state jail felony or a first degree felony or capital murder, it's all heard in the district court. This also includes all of your aggravated offenses, aggravated robbery, aggravated sexual assault, all of your injuries involving children or the elderly, um, assault with a deadly weapon, um, those types of cases. So a felony, I told you a misdemeanor is punishable by up to a year in the county jail. A felony is punishable to 6 months in the state jail, 2 years to TDC, which is the Texas Department of Corrections, all the way up to life imprisonment or a capital offense, the death penalty. Let's talk about venue. Venue is covered under Article 13 of the Code of Criminal Procedure. And if you look at the code, you'll notice that there are lots of different venue statutes available. Um, what you want to focus on is the general provision. Um, Venue refers to where the case should be heard, like the county or geographic location of the court. In order to determine venue, the prosecutor has to prove it by preponderance of the evidence. We usually presume that there's venue unless it's raised by the defense. The general rule for venue that you should remember is that a case should be tried where any part of the crime was committed. Sometimes a party, and this can be the state or the defense, may ask for a request for change of venue. Anytime there's a concern about venue is improper and there's concern about harming a witness or a party or prejudice. So let's look at, our first case, Jebediah Murphy, Jedediah Isaac Murphy v. State. This awful person killed basically someone's grandma. I believe they met at a bar, and he tried to get a ride or give a ride. Let me see if I can see if they actually tell us where it happened. But it all started in a bar. Yep, he was drinking at a bar called Bleachers. He hitched a ride with the victim, and he ended up making her get in the trunk and shooting her in the head, killing her. The medical examiner said that the victim did not die right away. So now we have someone charged with capital murder, and at that time, we don't have a specific venue provision for capital murder. So the question becomes, where is venue proper? And of course, he wants to challenge venue uh, cleverly, trying to claim that, haha, you can't convict me of capital murder. You don't know where she died at. Venue. So he basically wants to try to say that venue is proper nowhere because you have no idea where she died. Well, of course, the state of Texas is not going to let him get away with that nonsense. So, what happened? Um, the court decided to look at a lot of different places. So, at first, we know that she was shot. She was last alive in Collin County. He's driving through Dallas County, shoots her, and the body was found in Van Zant County, right? And we know that the appellant lived in Dallas County. The court decided that, based on the venue statute, Article 1319, if venue cannot readily be determined, um, then it can be where the defendant resides, where he is apprehended, or the county to which he is extradited. Okay, so that's that in terms of that. So he does not get his acquittal because we can't figure out where venue was. And the court decided that venue was, in fact, proper in that Dallas County where they were at. So that's a pretty clear cut case, but the issue of venue can be a little bit more complicated, especially when you have a concern about wanting to change venue. Anytime there's a concern that there may be prejudice to another party, that can be an issue. The primary party who likes to request a change in venue is usually the defense, but the state can request it as well. The parties can agree to change venue, a motion can be filed, or the judge can order the change. Usually venue goes to a neighboring county. They don't go to another state. You guys know that. And it's really hard if they go several counties away because of the travel, which we're going to talk about in a moment. So if the defense wants to change venue, he or she has to file a written motion with two or more affidavits. So his motion that's written with two or more affidavits from credible residents stating that the defendant cannot get a fair trial, and that in the affidavit they have to outline that there's a great prejudice and a dangerous combination of influential persons against him or her. The opposing party, in this example, would be the state, can certainly submit controverting evidence or affidavit saying yes, he or she can get a fair trial. The state can also um, ask for a change in venue if there are circumstances that show that there is some kind of favor for the accused, or there's a safety issue if the trial does not move. What if one of the witnesses is in danger or something like that? They can ask for venue as well. When deciding to change venue, the judge can hold a hearing. The timing can be either pre-trial or anytime during jury selection or wait to voir dire. It's not a bad idea to wait to voir dire because you get an opportunity to talk to the potential venere or the jury and determine, are they really biased? Now, I don't know if you remember this very sad case or if anyone lives in Galveston County, but this was the Santa Fe shooting. Um, think about for a moment some of the horrific cases we've had of violence. Think about the nightclub shooting in Orlando, Florida. Think about this person who shot up the school in Santa Fe High School. They all wanted, I mean, the Orlando person was killed, but it's very typical for people to say, oh, I need a change of venue. But one question that needs to be considered when you're asking about change of venue is not just about the defendant, but what about the other witnesses and the victims? Do they have a right or any interest in having a case heard in the community that was harmed? Let me give you some other infamous venue change requests. Venue requests for change of venue is very frequent. It's not always granted. We've got the Boston Marathon bomber who killed 3, injured over 260 people. They filed 4 motions to change venue, denied. Rodney King trial, venue granted, venue change granted, moved from LA to Simi Valley, and he was acquitted despite the video evidence, and riots happened. The DC snipers trial, where 17 were killed, injured over 10, that was moved to Virginia. Oklahoma City bomber Timothy McVeigh, and this rare in federal cases for venue to be moved. That was granted. He killed 168 people. The Ruth trial, which some people call the American Sniper murder trial, denied. Fort Hood shooter, if you remember that Fort Hood shooting, venue change, denied. Aurora Theater shooting, killed 12, denied. So all of these cases were high publicity cases, right? And it's very possible that everyone had heard about the cases, had read about the cases, yet in the vast majority of the cases, venue was denied. And I would suggest to all of you that publicity isn't going to be the end of the story, especially when we have 24-hour news cycles, especially with the internet and social media. It's kind of hard to find people who've never heard of a high-profile case. So this is a clip from the Justin Ross Harris trial. This is the man who was tried for leaving his infant child in the car, and evidence was presented that he did it on purpose, that this wasn't one of those, oh, grandma forgot the kid was in the car. We think he did it on purpose, and he wanted a change in venue. And I want to share with you some of the considerations that were raised. Let me play it and go fast forward it some.
Argument suggesting their prayers for relief, and one of the prayers for relief was that the court move to some other jurisdiction, select a jury from that community, I guess put them all on the bus, bring them up here, put them in a hotel, and try the case with them. There is no way in the world that I would ever consider doing that to anybody, period. It's going to be hard enough if we stay here or we go somewhere else on jurors to be on a long case in a jury room all day away from family and business and other things, but still be able to go home in the evening. But to pick people up out of a community totally strange to our community, select them, and then take them away for 4 to 6 months and put them in a hotel here, away from family, friends, what business they might be able to conduct over the evening hours or over the weekends. I mean, if we did that, we would work through the weekends, because I'm not going to do that to other people. So that is just a non-start. That is just not going to happen. So I discussed the logistics of a change of venue with the court administrator, Mr. Sharon, who's here. And there are a lot of things I want both sides to start thinking about. Who is going to accept us? So where are we going? It is not going to be a metro area. It can't be. So we're going to be out possibly in some rural area. What kind of accommodations are there going to be for us? I mean, it's not that we can't do this. Venue is changed regularly, but y'all need to think about this. Think about the expense to the taxpayers. I want you to think about the wear and tear on all of us if we pick up and go somewhere else. And witnesses traveling up and down the highway, because it's not like we're going to go to Macon. I don't see that as a possibility. That's not too bad. I've done a change of venue case in Macon. It's an hour and a half down the road. What about security in a courthouse where people have not been exposed to media coverage of this case? There are courthouses in Georgia that have no security. They don't even have air conditioning. And that's true. Not many, but I know at least one exists. The press. There is a tent city. You can see it out my window. So what about them? If we take up all the hotel rooms, where are they going? Of course, they have big fancy vans. I guess they can sleep in their van. I don't know. I've never been in one. We are talking about the likelihood we end up in possibly a rural community with very limited amenities away from our support system. Now, last Thursday or Friday in Chambers, we had an in-Chambers meeting, and it was very productive. We talked about scheduling items, which we can do off record.
Okay, so let me pause there. I think most people, particularly students, don't realize when you ask for a change of venue, you don't get to get a new judge or a new prosecutor. You're basically asking for everyone to move. So if any of you have interned in a court, can you imagine stopping the docket? Because generally, when we're in trial in court, the judge will maybe start the trial back at 10 o'clock or have recesses. And in between recesses, the prosecutor and the defense attorneys are still working out the dockets. During the recess, the judge will take pleas and then go back to trial. It's very rare, even though that's not what people see on TV, it's very rare for a trial to happen for days or weeks and everything just stop in terms of the other business of the court. When you change venue, you are stopping the other business of the court because the judge is gone, the bailiff is gone. You know, all those people have to travel with the judge. They don't say, "Oh, we'll provide you a judge and a clerk." No, it's your case. You're stuck with those people. So I would say that because of those concerns, that may be another reason why judges and courts are very reluctant to change venue, even in those high-profile cases. Now, this is Justin Hurst. Justin Hurst was murdered. He's the fallen game warden in this James Freeman case. Anytime an officer is shot, it's a horrible thing for the community, and it brings with it a lot of publicity. This is the person who is accused and I believe convicted of shooting that game warden. And this is Kelly Siegler. And I have a picture of Kelly Siegler. Kelly Siegler was my misdemeanor. They called her the deputy dog, the misdemeanor trial division chief when I was a prosecuting attorney. Her reputation was one of never losing a felony case, including capital cases. She was a very prolific prosecutor, and is now on the TV show Cold Justice, where she talks about prosecuting cold cases. So this case happened in 2011. We have a killing of a game warden, and the defendant wants a change in venue. And with that change in venue, he fills out the paperwork, and guess how the state responds? The state responds with 372 affidavits. And under the law, they can respond with controverting affidavits. And we've already established that the community often does have a strong interest in wanting cases tried where the harm occurred. The Defendant argued that by doing that, the murder was just further publicized, that it was an attempt to influence the judicial process, and it was a concerted effort to keep the trial in Wharton. And what else happened is by hiring this hired gun, they would call it, as a special prosecutor, Kelly Siegler, who was well known in Texas, that it further publicized the case. So the standard of review, anytime you're dealing with a change of venue, is abuse of discretion. And remember, we said that is the most deferential standard there is. Okay. So we also established that there are different ways the court can determine whether or not to change venue. And in this case, they could do a hearing of voir dire. The court actually did both. They held a hearing and they waited to voir dire. And they had to listen to a bunch of jurors. Let's see. Um, they tried to argue that the potential jurors with knowledge, and you need to call, all those Veneri 1,200 were called. That demonstrates by itself that you can't get a fair trial in Wharton, Texas. The court wasn't convinced by that. The court, I think, had to do two panels, right? Um, let's see. And the appellate court decided that the trial court was within its discretion. Remember, the standard review is abuse of discretion, to believe that the prospective juror statements that they were not unduly influenced could deliver a fair verdict was reasonable and not abuse of discretion. Um, and there was no abuse of discretion when many of the Veneri said they may have formed an opinion that could not be set aside. With pretrial publicity the way it is, there's going to be a time where everybody knows. So part of the problem with the defense meeting as burden of proof here was, you say that there's a lot of publicity, so what? Can you show that this publicity has impacted them, or that the community has even kept up with this pretrial publicity? So the trial court said the pretrial publicity in of itself was not enough. And in the end, it all boiled down to the trial court using his or her discretion um, in judging that credibility of the jurors, something that the appellate court could not do. Let's talk about charging decisions. Charging decisions begin with law enforcement. So if you remember the first day of class, we talked about a crime occurs. And in Harris County, Texas, when a crime occurs and the police investigate, they go through a process called intake. Now, all DA offices have an intake procedure, but the procedure differs. In Harris County, Texas, intake consists of the police officers calling a DA. The DA's intake division is open 24 hours a day, 7 days a week, including holidays. And they'll say something like, hey, DA Mathis, I just pulled over a defendant for running a stop sign. And when I approached the vehicle, he had a strong odor of alcoholic beverage, glassy eyes, slurred speech. I asked him to get out of the car. He stumbled out of the car. He failed his field sobriety test. Will you accept charges for DWI? And based on that oral summary of probable cause, I have to make a decision. Now, I have the law ahead of me, in front of me, and I have my experience as a prosecutor, but I make a decision on whether or not someone's going to be arrested at that moment or they get to go home. And based on that kind of fact pattern, I would probably say charges accepted. Now, sometimes a police report, especially if we're talking about more complicated cases, arson investigations, you're going to have the DA will actually get to read the police report ahead of time. Sexual assault cases involving children, oftentimes they'll let the kids go to the Children's Assessment Center, and so they'll read those statements ahead of time before making charging decisions. But the vast majority of cases are decided initially just through that simple intake process. So the prosecutor's job is to understand the crimes and the elements, although you'll have your case book with you, you'll have the computer with you as a resource. Officer makes that oral summary. Sometimes I have requested that the officer fax the report, especially if I say charges denied. and they're mad, and they'll say, well, I need a written denial. Well, I'm like, fax in the police report. I'll give you a written denial. You can also request additional evidence. Frequently, for example, in domestic violence cases, I would say, I need you to take pictures of the victim's injuries, right? Because I know that there's a chance that my victim won't cooperate later, and I'm not going to have any evidence that anything happened at all. Or if it's a shoplifting case, I'm going to say, did you get the surveillance video? No, they won't give me to you. Okay, tell them I'm not taking charges then. Oh, suddenly Walmart wants to cooperate and give us the surveillance video. So sometimes you can request more evidence and you make that mental assessment. Now, when I was a DA, you follow the bond or bail schedule. Now they just make a recommendation. And now, unlike before in the past, where they didn't think that the initial probable cause hearing was a crucial or critical stage in the criminal justice proceedings, now there is someone from the public defender's office ready to assist all defendants in arguing about what bail should be. And that's a direct result of the O'Donnell lawsuit that we talked about during our last class. So, in terms of charging decisions, there's been a lot of discussion about prosecutorial discretion, and it is a very big deal and is very powerful. Ethically, a prosecutor should not prosecute or threaten to prosecute any case that he or she knows is not supported by probable cause. A prosecutor is also not free to put unfounded allegations in an indictment to make it look like a plenitude of accusations will make the defendant look like a criminal, right? So just because I can charge you with 20 cases doesn't necessarily mean I should. If there's a case involving a victim, even if it's a misdemeanor, you're getting charged with that. If they're the highest charge, you're getting charged for that. Charges where victims, may get restitution or something like that. But I may not worry about the misdemeanor case if there's not a victim involved, right? Or I may not need all 50 counts. What does it do to a defendant if they're facing, 20 counts versus or charges versus one? Well, it impacts their bail. It impacts their ability to get representation because now, even if they can hire a defense attorney, that defense attorney is going to look at all the charges and they're going to charge more for that representation. So you need to make sure ethically that you charge, the appropriate amount, but not just to be charging any and everything as a prosecutor. A factual basis needs to exist for each and every charge. Every element that you have in that charging instrument needs to be proven beyond a reasonable doubt. Your job as a prosecutor is to match the facts to the elements. So, in terms of drafting the complaint, a complaint is that sworn statement that alleges that someone did something. That complaint is usually sworn off by the peace officer. The police officer will do the complaint. The defendant must receive notice of a complaint no later than the day before the date of any proceeding in the prosecution. Hence, in Harris County, we have probable cause court. So, before really anything happens, and they're open 24 hours a day, defendants are taken before a probable cause court to make sure that they know about any and all allegations. Now, I have some examples I posted already. Let's talk about the felony indictment as I pull up an example from that, which means I'm going to have the fun process of returning to my share screen and giving you a new share. I'm going to share from screen 3. Okay. Hopefully, what you're seeing on the screen now is a draft document. This is a misdemeanor information. So there are 2 charging instruments in Texas. It's the misdemeanor information or the felony indictment. So obviously misdemeanors are charged by information, felonies by indictment. Now take a look at it. We've got state of Texas, we've got Jessica Garrett, we've got the charge assault, and then we've got the statement in the name by the authority of the state of Texas before the undersigned assistant district attorney of Harris County, Texas, this day prepare the undersigned affiant who under oath says that he has good reason to believe and does believe in Harris County, Texas, that this person, the defendant, on this day, unlawfully, intentionally, and knowingly caused bodily injury to that person, the complainant, by striking the complainant with his hand against the peace and dignity of the state. It's signed. It's signed by the affiant, that would be that police officer, and the district attorney. Okay, that's the complaint. And the information would do the same thing. Um, and then we have our felony indictment. Notice looks the exact same way. This is the complaint for Mr. Leon. Has the same language and name and authority by the state of Texas. We believe that he intentionally, knowingly, unlawfully possessed controlled substance, cocaine. And it's signed by that police officer and the district attorney. We keep going. It's another complaint. Sometimes the complaint statements can be lengthy. This is an aggravated assault. I believe it's on Lexis Classroom as well, so you can pull it up for yourself. But this gives a very long probable cause statement about what happened in that aggravated assault case. But what I wanted you to see, this is what the actual indictment looks like. Now, notice that the misdemeanor information is signed by the prosecuting attorney. A felony indictment has to be signed by the foreman, or in this case, the assistant foreman to the grand jury. Remember, we talked about grand juries, and all felonies should be indicted by the grand jury. There is an exception to that, which we'll get to soon. So here we have, in the name and by the authority of the state of Texas, the duly organized grand jury of Harris County, Texas, presents in the District Court of Harris County, Texas. That in Harris County, Texas. Why do we keep mentioning Harris County, Texas? Because jurisdiction and venue matter. The named person hereafter styled the defendant, heretofore on or about a certain date, did then and there unlawfully, intentionally, knowingly cause serious bodily injury to this person, hereafter called the complainant, by striking the complainant with an unknown object. Then we have what's known as an enhancement paragraph. An enhancement paragraph is used to enhance the level of punishment. So this person has been convicted before of a felony. It says, before the commission of this offense, on this date, in this case, in this court, in Harris County, the defendant was convicted of this felony. So that would make a normally, second degree felony looking at a first degree. So let's say, and I can't remember if aggravated assault is a third or second, I think it's a second. Let's say, for the sake of argument, before, he may have been looking at a punishment range of 2 to 20 years. An enhancement paragraph could bump or enhance the level of punishment to where the minimum, instead of 2 years, is now 5 years, 5 to 99. Notice is still signed against the peace and dignity of the state, and is signed by the grand jury foreman. So let me go back to our screen and share screen too. Okay, so hopefully you guys see the requirements for felony indictment. Let's go through them. All felony indictments have to start with, in the name by the authority of the state of Texas. They have to appear in the same was presented in the district court of the county where the grand jury is in session. It must appear to be the act of the grand jury of the proper county. It must contain the name of the accused, or if the name is unknown, a reasonably accurate description. It must show that the place where the offense was committed is within the jurisdiction of the court in which the indictment is presented. That's why you saw all those references, for example, to Harris County. The time mentioned must be some date anterior to the presentment of the indictment, but not so remote that the prosecution of the offense is barred by limitations. So it can't be barred by limitations. We're going to get to limitations soon, but just keep in mind, most felonies are 3 years, most misdemeanors are 2, but there are some specific statute of limitations depending on the case. For example, murder has no statute of limitations. Rape, sexual assault, I believe, is 10 years. The offense must be set forth in plain, intelligible words. Indictments must conclude against the peace and dignity of the state. And you saw that in the documents that I showed you. It shall be signed officially by the foreman of the grand jury. That's under Article 2102 of the Code of Criminal Procedure. And here's another example of that felony indictment. The misdemeanor information, a little different, still in the name by the authority of the state of Texas. has to make sure the court has jurisdiction, presented by the proper officer, contain the name of the accused or reasonable description, um, place where the court has jurisdiction, time mentioned, not barred by limitations, set forth in plain, intelligible words, conclude against the peace and dignity of the state, signed by the district or county attorney. And that's Article 21.21. And so here is another example of a misdemeanor information. Notice, remember, the complaint was signed by the officer and the DA. The information is only signed by the prosecuting attorney. So here are some common themes to all charging or both charging instruments. Name of the state of Texas, name of accused or description, crime must have occurred before presentment and comply with statute of limitations, plain English, conclude against the peace and dignity of the state, signed. So here's an example of a bar question from July 2008. You're not going to give this as a bar question because you're going to be doing the UBE, but I think this is still fun to look at. They gave a language from a charging instrument and said, what's wrong? I'll go ahead and give you the answer. It needs to commence in the name by the authority of the state of Texas. It doesn't do that. Specify the district court, state the county, the date, and it needs to be signed by the grand jury foreman, not the ADA, if it's a felony indictment. You could sign it by the ADA if it was a misdemeanor information. Now let's talk about the language in the charging document. The state has to allege what's known as the manner and means of committing an offense. So it's not enough to say that you assaulted the complainant. You have to answer how. And how is related to the manner and means. So if I said you tortured an animal, that's insufficient notice. You tortured the animal by beating it with a baseball bat. That's sufficient notice. What if there's something wrong with the charging instrument? Well, one common thing for a defense attorney to do is file a motion to quash. If you've ever gotten a traffic ticket, sometimes we'll see citizens that will get a traffic ticket and they'll say, oh, you misspelled my name. And basically they're asking for a motion to quash and the case to be dismissed because there's something wrong with that charging instrument. What oftentimes they don't realize is that the government can always amend to cure the defect. So sometimes we'll have defendants who are very upset because they'll say, I thought my case was dismissed. Well, the state gets to refile. The whole point of a motion to quash is to attack the face of that charging instrument. It has to be in writing. It should be made before trial, but the court does have discretion to grant or deny an untimely motion. So charging instruments, I've already given you kind of a hypothetical. The job of the person to make sure it's a good charging instrument, if there's any problem, that's on the prosecutor. Let's talk about the State v. Stephen Barbanal case. And you see that I have someone doing a field sobriety test, if you know anything about field sobriety tests. And he's doing pretty badly because that's not his nose he's touching. So in Barbanal, he was charged with DWI. And frequently, when we charge someone with DWI, we have an alternate manner and means paragraph that says how they were intoxicated. So we'll say something about the person unlawfully, knowingly, intentionally committed the offense by driving while intoxicated, by either having a blood alcohol or BAC of over 0.08 or losing the having the loss of his mental or physical faculties. Okay, they'll have some language like that. In this case, we have a charging instrument that basically said that he was driving while intoxicated by operating a motor vehicle in a public place, the end. And it never really went into how they were intoxicated. Now, this was an interlocutory appeal. It was an interlocutory appeal, and you may remember from early legal research and writing days, that is an appeal in the middle of a case because basically the judge said, we're done. That ends the state's case. And that's one of the few opportunities where the state can appeal. Normally, the state can't appeal. The state loses, that's it. We're worried about double jeopardy. This is one of those situations the state got to appeal, and they did appeal. you know. And the court, although they said you failed to allege which definition of intoxication you were going under. Was it BAC, or was it just the per se standard definition of losing your mental or physical faculties? And the court said, it's about notice. And in the end, the court says, no, this goes to show the evidence that will be admitted to prove intoxication. This is not an element of the offense that must be alleged. And if you look at the DWI statute as they published here, they let you know that the whole definition of intoxication is under just that. It's under the definitional section. But the penal code defines DWI very simply. A person commits an offense if they're intoxicated while operating a motor vehicle in a public place. That's your notice. And that's what the court decided in the Barbanel case, that notice was in fact sufficient. That was a different result from Neil Cook v. State. Here, the prosecutor went a little bit crazy. What did they do? They forgot, oh my goodness, to give the name of the defendant. And you just can't do that. At a bare minimum, under our state constitution, every indictment has to at least name a person and that they committed a crime. And this is because of jurisdictional reasons. If you don't do this, the court has no jurisdiction. So the court says, no, you're right. This is a totally invalid indictment. How do you fix a bad charging instrument? Well, there's a couple things you can do, couple meaning two. One, you can amend it. An indictment can be amended before trial if the defendant is not charged with additional different offense and the defendant is not prejudiced. So let's say, this is a good example here. The defendant is charged with aggravated assault. Aggravated assault is very different from credit card abuse. So if the day of trial, the state says, I can't prove ag assault, I'm going to amend the indictment to allege credit card abuse. Credit card abuse has nothing to do with aggravated assault. That is clearly a different offense. It will clearly prejudice the defendant. That's a non-starter. You have to go back to the grand jury if you want to charge them with that case and get it indicted. If it is a more valid amendment, right, and it doesn't charge you with an additional or different offense, and you just want to amend to correct a spelling of someone's name, or you want to say, it wasn't a unknown object, it's actually a baseball bat. We know that now. You can do those kinds of things to change it. The defendant automatically, whether the judge likes it or not, gets 10 days to respond. So it's basically an automatic continuance. Can you amend something after trial occurs? Yes, if the defendant does not object. Future defense attorneys, don't you dare ever not object to someone wanting to make an amendment in the middle of trial. Don't do it. In order to do that amendment, the prosecutor must physically amend the document or photocopy. So basically, think of it as a correction. The other way to change or correct a charging instrument is an abandonment. There is no 10-day notice requirement. Abandoning means that you're getting rid of excess language, something that you don't have to prove. Best example is an alternative manner and means. So let's go back to that DWI example, and let's say I allege that the person committed driving while intoxicated because he had a BAC of 0.08 or because he lost the normal use of his mental physical faculties. And let's say my blood alcohol test is messed up for some reason, and I want to abandon that. He's still being charged with DWI, right? I'm just changing one of the ways he or she could have been intoxicated. It's excess language. So if it's excess language I don't have to prove, I'm good to go. I remember there was a felony prosecutor, and it's really easy because the DA's office has lots of movement in big cities in particular. It's very easy to be in one court on Friday and be assigned to a new court on Monday with cases that are going to trial, or to be so busy with a crushing caseload that you don't realize or you fail to clearly study your charging instruments. The biggest takeaway from today's class, your charging instrument is everything, because you have to prove what's in that charging instrument beyond a reasonable doubt. So we had a felony prosecutor who had a sexual assault case, and there was something involving a knife, and she didn't have that proof, and she was able to abandon that information, and she didn't need to do 10 days notice, and she was really worried because of the timing of everything. So sometimes, if it's just extra language, you don't have to worry about amendment. You can abandon it. So amendment, changing the language before trial, 10 days notice. Abandonment, striking through language on the charging instrument. You don't need notice. You don't need the defendant's approval because it's excess. And then we'll get to making objections in the Till case on page 189. All right, this was an interesting case. We have a tip that a fugitive is staying at someone's home, outstanding parole violator and sex offender warrants. And the officer said, they're felonies. Are they here? And he said, no, they're not here. No, you can't come in the house. Well, the officers hear noises, and the dum-dums decide to leave the house. They could have just stayed at the house. They would have been found. But because they decided to leave the house, we got them. And the appellant was indicted for hindering apprehension. And what did they do? Well, they didn't mention the charge, the underlying offense that the person was charged with, because under this particular statute of hindering apprehension, it can be a misdemeanor or felony depending on what the fugitive was charged with. So in this case, the defense clearly knows that there's a problem with the charging instrument, something the prosecutor should have caught too. And the defendant waits until the jury is sworn and impaneled. Why is that important? Because that is when jeopardy attaches. We're going to talk about double jeopardy later on in the semester. But the moment you pick a jury, they're sworn in and impaneled, they take their oath, that's jeopardy. Okay? And so the defense figured out that, now that they've been sworn in and impaneled, you don't have jurisdiction, felony case. This should be a misdemeanor. And the court went through some pretty lengthy history, really focusing on the defendant's trial tactic and the fact that this information should have been raised before trial, or you waive it. You can't invalidate a conviction because you lied behind the log. And the whole reason we changed this whole issue was because we didn't want these technicalities to impact the conviction. So the legislature actually made these important changes. So was there a missing element in the indictment? Yes, there was. Definitely a missing element in the indictment. But they found that the district court could conclude from the face that the state intended to charge hindering apprehension. But nonetheless, even without that, you should have objected before. You waited too long. And that's really one of the takeaways. You don't get to hide that kind of important information because you think you're going to get a tactical advantage in appeals. That just will not work. And then we get to variances. Perry Montez Johnson v. State. And here we have an issue of the charging instrument itself. The person has allegedly committed the offense of aggravated assault, and there is an issue of whether this was committed by hitting or throwing them against the wall. The lower court said, yes, there's a variance. And when you think variance, I want you to think difference. Okay, there is a difference between what they said they were going to prove, but it's not material. And so they talked about the whole thing with the different variances, statutory variances and non-statutory. And so if you look at page 196 of your textbook, it reminds us that a variance can occur in two different ways. First, statutory language that defines the offense. When a statute specifies alternate methods in the way that an offense can be committed, and the state proves an unpled method. Okay. The other is when you have a non-statutory allegation that is descriptive of the offense. Um, for the first type, when you don't prove the statutory language pled, it renders the evidence legally insufficient to support the allegation. Um, but if it's a non-statutory allegation, they tolerate those types of differences. So if it's already in the language of the statute, can't have any variance with that. But if it's a non-statutory allegation, then they believe that those kind of mistakes, they quote, do not prejudice the defendant's substantial rights. Um, so the variance should not be so great that the proof shows an entirely different offense, but it's okay to have small differences. So let me go to this next because I think this slide helps a little bit more. A variance occurs anytime the evidence proves an offense that's different than what you charge in your charging document. Remember, we said the charging document's everything. So if you were talking about an element in the statute, that's a statutory variance. And a statutory variance is always material. It requires an acquittal, game over. And in this case, they found not just two variances, but they decided to categorize them into three different variances. And they did that on page 197 to 98. They said variances can be classified into three categories depending on the allegation. First, involving statutory language that defines the offense always renders the evidence legally insufficient to support the conviction. Second, a variance involving a non-statutory allegation that describes an allowable unit of prosecution element of the offense may or may not render the evidence legally insufficient, depending upon whether the variance is material. Finally, other types of variances involving immaterial, non-statutory allegations do not render the evidence legally insufficient. And they found in that case that it was the third type. So a non-statutory variance, part of the charging instrument, but it's not explicitly in the statute itself. So think of an assault case. Assault case causes bodily injury. That's in the statute. The manner and means in terms of how the assault occurred, whether you kicked them with your foot, you struck them with your hand, that's the manner of means. That's not statutory. So if you charge someone with assault for breaking the victim's arm, the offense is the same, the offense itself, whether you broke their arm because you twisted it or you threw them against the wall. That's a non-statutory variance. Okay. It would be material if the evidence showed something completely different as an offense. Okay. We haven't changed the offense by the manner and means in that example. Hopefully that makes sense, and I'll be happy to clear this up when we're in class together. Statutory variance relates to an element listed in the statute. Always material, requires acquittal. This is just a recap. Variance occurs when the evidence proves an offense is different from what's charged. And what about counts? And remind me to also talk about, because there's another good example of units of prosecution. But think of multiple victims. So in terms of units of prosecution that they refer to on page 196 of this case, if there's an arson and 3 people die, there's still only one allowable unit of prosecution because the crime of arson is setting something on fire, even though the result was horrific and someone died. Murder, however, each victim is an allowable unit of prosecution. So in that case, you could have 3 charges of murder, if that helps. So sometimes we use the word counts. And that's also related to that whole unit of prosecution. One charging instrument can have several counts. We don't do that a lot in Texas. It can happen though. The federal system does it all the time. They'll have one indictment with lots of different counts. In Texas, we tend to generally do separate charging instruments, but we can do it all in one. Joinder, and there are 2 types of joinder. Today we're going to talk about charging instrument joinder. Joinder refers to the ability to charge multiple offenses or multiple offenders in one charging instrument, as long as it's out of the same criminal episode or same transaction. Trial joinder which we'll talk about at the end of the semester, is when you try co-defendants together. Right now, we're just talking about charging instrument joinder. So it is okay to have multiple charges in one charging instrument or multiple defendants. And then nollie. What is a nollie? A nollie, it stands for a Latin term, is the ability to dismiss a case. As a judge, people ask me all the time, Your Honor, can you just dismiss it? No, it's not my case. It's the state's case. It is the state's responsibility to dismiss the case. I have limited powers to listen to the state's recommendation and push a button or fill out the paperwork and put my signature to it. But I cannot sua sponte dismiss a case on my own. They used to be back in the day, but they changed the law and they reminded us that it's the state that brings the case. It's the state who needs to move to dismiss. As a judge, I can certainly find that there's no probable cause. I can find that evidence needs to be suppressed. I can grant a motion to dismiss or a motion to quash. But it's the state's responsibility to fill out that nollie. Counts. I feel like I went backwards. We did that already. That's it. All right. So that is the end of our class. I hope it's helpful. There is a quiz. So hopefully you listen to this to the very end. There is a quiz. I want it to be a closed book quiz. It is posted on Lexis Classroom. It has some questions related to today's lecture, as well as things we've gone over in the past. So make sure you do the quiz, and I will see you at our next class. Have a great day.